Hi, my name is Carlos Villamar, and I'm a recovering patent attorney. The reason I say that is I'm not the only one with the deer in the headlights look. I think the whole patent bar, and I know there's a few experts out there, and I've always been told the definition of an expert is somebody that knows a little bit more than you. Hopefully, I'm an expert, at least with some of the topics that I'm talking about. Just to give you a little bit of background, I stumbled into patent law. I was an engineer for 10 years. I'd worked at General Dynamics. I went to Hughes Aircraft and worked in their R&D department. I helped design the YF-22 Raptor. And there I was in 1994 in California working for Hughes. And we had just worked a year around the clock on this Raptor program. We were taking what's called the proof of concept, which is basically also known as a breadboard. And we were converting it to the actual units that were going to go into the planes. So basically we were taking these gigantic racks of boards and shrinking them down into ASICs and putting them on the actual modules that were actually going to go in the actual aircraft. Now we worked, we had 1 year to go from proof of concept to the actual hardware design. It's called the gold box, or the first basically aviation box. And we were really, I was working probably about 16 to 18 hours a day for a year straight. We had 3 shifts running 24/7. We kept lab notebooks. We documented every single thing that we did with respect to the project. I had program managers breathing down my back every day, telling me if everything's going okay. And at the end of the day, we pulled it off. We demoed the unit. We were competing against Northrop and some other, basically it was 2 teams. It was Hughes Aircraft with, I believe, General Electric, and it was Northrop with somebody else. And basically, we demoed the unit, and it worked perfectly. We designed what's called the Common Integrated Processor. It's basically the flight computer for the for the Raptor. And after we finished this, we go into this hurrah dinner, which is basically where they took us in and told us what a great job we did. And they proceeded to tell us that production wasn't going to start for 2 years, and that everybody in the room was going to get laid off. So that was the point that I became a mercenary. Up to that point, I was go Hughes, Hughes is great, I love Hughes, and all of a sudden I realized that, if things change, they would lay you off on the drop of a hat. In fact, I saw Hughes Aircraft go from 80,000 to 40,000. I was in a cubicle with 4 engineers, and there was only myself left and 3 empty chairs. And I said to myself, I need a plan B. I didn't have a plan B, but I knew I needed one. This was back in '94. If you recall, back then there was a big crash in California. All the aerospace companies laid off. Being an engineer was actually not such a great thing at the time because of all the layoffs. And then I took a scuba class, and one of the guys in the scuba class was actually inside counsel for Hughes. He was a patent counsel for Hughes Aircraft. So I looked at him and I said, hey, what's a patent attorney? And he goes, well, you got to be an engineer. And I go, check. You got to go to law school. And I said, what's law school? I mean, I didn't mean I knew what law school was, but I meant what does it entail? And he says, well, it's 3 years during the day, 4 years at night. I said, okay. And then I asked him how much he was making, and he was making twice as much as I was as an engineer. I quickly calculated that it would take me about 15 years at 7% to get up to where he was in pay. And that second, I decided to be a patent attorney. I said, I'm going to become a patent attorney that second. And I've always been very decisive, for better or for worse, but once I make a decision, I go with it. I took the Caton course, or whatever course was available at that time. I sat for I took the LSATs, and then I did something that made me an inventor before I even knew it. I mean, at Hughes Aircraft, we had invented, we were the first ones to design software-defined radio. We have the initial patents on software-defined radio. I actually designed the first unit that used our super high-speed A to D converters for the software-defined radio. But at the time, I didn't know it was patentable. I said, oh, I'm just using known components. It's not a big deal. But looking back at that design, I realized that basically I probably have prior art against software-defined radio in that design that I did back then. So I went off to law school. Yes?
Can you use this mic? The mic's, for some reason, it's cracking on your voice.
Oh, is it? Okay.
Yeah, just turn that one off.
I do talk loud, too. I probably don't even need a mic.
It's just the pitch of your voice that's
Okay.
making it crack, only on the online.
Okay, is this any better, I hope? So anyways, I came to Washington, D.C., and of course I was trying to apply to law schools, and I figured, how the heck am I going to apply? I've only got a limited budget, and there's all these law schools all over the U.S., so what I did is I put all the stuff from the LSAT book into a spreadsheet, and I sorted it based on criteria like what my chances are of getting in based on my GPA and LSAT score. I sorted the spreadsheet, and I applied in the first 12 schools because that's all the money I had. I had 50 bucks times 12. Well, as it turns out, when I went back and resorted the spreadsheet, George Washington waitlisted me. Every school below George Washington accepted. Every school ranked above George Washington declined. But I got in 7 out of 12 schools, and in fact, later on, companies developed software related to how to get into college, business methods.
Turn the lavalier off. There's a switch on it. It's still picking up.
It's off.
Is it? You said it was still picking up. Why don't I take it? I'll make sure.
It's probably just me coupling into multiple. So anyways, I ended up, working as a patent attorney, and this story does have a purpose, and I will get to it if you could bear with me a little bit. So now here I am in DC, and I'm thinking I'm an engineer. I should be able to get a job anywhere. And I've got still 50 rejections from the first law firms I applied at. They didn't care that I was an engineer and that I had gotten into GW. So finally, I went to the patent office, and I worked as an examiner in the speech signal processing group. And finally, after doing that, all of a sudden I got a call from the Oblon firm and got hired by them to do patent prosecution. Now, the reason this story is important is because I represent small inventors and startup companies. I always have. When I went to all the law firms that I've been to, they said, go get me Motorola, go get me Nokia, go get me Ericsson. And of course, me being a lowly associate going up to Ericsson and Nokia, they didn't give me the time of day. The only market that was available to me to develop clients was the small inventor and startup market. There was a huge problem, though. They had no money. They still have no money. And I would go to these small companies. I'd say, hey, I can do a patent for you. I've got good expertise. I'm well trained. And they say, how much is it going to cost? And I'd say, well, it's $10,000 to $20,000. Give us $10,000 and we'll get on it immediately. And they would walk away. And of course, I was wondering, well, what is wrong with this picture? And really, the light bulb going off was when I was working at Nixon Peabody, and the president gave away the book, The World is Flat. He said, anybody who wants this book can get a free copy. So I immediately got the book, and I'm reading it, and I read the book, and I come in the next day, and I'm talking to all my attorney friends, and I'm going, wasn't that a great book? Did you read it? Wasn't it awesome? And they're like, what are you talking about? All our jobs are going to India. We're going to lose our work. We're going to be replaced by Indian PhDs. And I looked at him, and I started laughing. I said, you missed the point of the whole entire book. If you don't add value, get out of the equation. That's how I summarized that book. You're welcome to read it, but that's what I got out of it. So at that point, I said, okay, why is it that patents cost $10,000 to $20,000? Well, it's the attorney. I was charging $500 an hour, for labeling the network 20 is connected to the computer 10 and the server 25. And when the light bulb actually went off was when I realized that when Oblon hired me, they didn't hire me because, well, the fact that I was in law school was important because they wanted me to become a patent attorney eventually. But they hired me because I was an engineer for my technical expertise. And they trained me how to write patent applications. And I didn't have a law degree. I wasn't even a patent agent at the time, and I was writing patent applications. And that's when the light bulb went off, and I said to myself, well, they taught me how to write patent applications. Why don't I teach inventors and small startups how to do the same thing? And that's when I started my business model. It hasn't been copied yet because most law firms are looking to extract as much money from a given client, where my model is, how can I minimize my cost to the bare minimum in order to produce the same work product that was being charged $10,000 to $20,000. I've taken that range and cut it down to 3 to 8K. And basically, my model is I teach inventors how to fish. Instead of selling them the fish, I teach them how to fish. It saves them about 70% in the costs. The reason this is relevant is because even though right now I am brutally efficient with startups and small inventors, I've taken that range from, from 10 to 20 down to 3 to 8K for the same exact work product. But now I look at all these changes in the patent law and I'm thinking, inventors and small startups couldn't survive before barely. I mean, at least with my methods, we could get patents filed cheaply where they weren't being filed before. But now, I'm really questioning what's going to happen. I mean, what are small inventors and startups going to do? I know to file early and file often. I mean, I've been, I looked at all the slides and all the best tips and all the practices. I've already been doing that from the very beginning. I've used electronic filing not because it was cheaper, just because it was faster. It saved me time from driving my car over to the patent office to hand carry a filing. I used the forms because I didn't have pre-filled forms like I did at other firms. I used the ADS because I heard it was easy to change information by using the ADS. I filed provisionals early and often because I knew that you needed to protect innovation as quickly as possible, not for the reasons that were mentioned here today, but just for setting your mark in the sand. Now, I never filed what I call crap provisionals. I had lots of clients coming to me and saying, oh, I was told that this attorney can file a provisional for $100, And I said, yeah, but it still has to be enabling or else you've filed nothing. I learned today that maybe you can get conception out of it, but my goal was to get a priority date, not just mere conception. So from the very beginning, I was teaching inventors and startup companies how to do it right. And by the way, it's not that hard. They taught me how to do it at Oblon, and I am a rocket scientist, but it can be done. I knew that any engineer can actually learn how to write patent applications. So anyways, I mean, the points that I'm trying to make here is that even with all these best practices that I've already instituted from day one, I'm questioning how small inventors and startups are going to survive now, because now, even if you're file off and file early and I figured out a way to do it very cheaply. I mean, I've solved that end of the puzzle. The question is, now what happens when a large corporation, starts instituting these sorts of proceedings against these patents of these small companies? As it was hard enough for them to protect the innovation from the very beginning. How are they going to defend these gigantic lawsuits that are going to occur? I heard, for example, these inter-parties examinations, once they start going through trial and everything, can cost hundreds of thousands of dollars. Startup companies don't have that kind of money. The worst part about that in the United States is that there's no help for startups. I've been doing a lot of work in Finland. At least in Finland, there is a mechanism to get money from the government to fund startups. I think that's the only solution in the United States, unless the United States gets a model similar to Finland, which, by the way, is a social democracy. I really, really believe that this legislation may be the death nail of small inventors and startup companies. So, when the previous speaker, David, got very emotional, I can understand why. I can really understand the problems, and now I will go ahead into the rest of the talk. I got put on this panel fairly quickly. I didn't have as much time to prepare, and also, as many of you, I actually had to do a PCT filing like the day before. So not only was I trying to prepare for this, but I actually had to learn the rules in real time. I did this PCT filing, and I realized that it implicated this oath and declaration issue that I was going to cover anyway, so I think this talk actually was sort of perfect timing for me, because what happened was I had a case where I had a U.S. application, and it was filed about a year ago, but I was filing it after the magic date. I just filed it a couple days ago, and of course the question was, what do I need to do to avoid having to file these petitions when inventors go hostile? I mean, when I look at the oath and declaration changes, it's the one change that I'm all for, because I've seen what it costs to get a hostile inventor, out of the loop. My own brother had a company that I represented, and we spent $30,000 in petitions trying to get his partner off of the list after the guy had already assigned the case, had already signed all the papers, but decided to go ballistic when we entered the national stage. So when I was filing this PCT application, of course, this sort of nightmare scenario came to mind, and I realized that, you know, I had to do something, and that something was get an assignment filed ASAP because the inventor had not filed an assignment yet. And one of the requirements for PCT in order to, you know, to be able to list the applicant, i.e. company, as an entity, is that there has to be a valid right for that company to have that IP. So I knew that I had to get an assignment filed ASAP, and I did. I filed it the day before I filed the PCT. Then the day that I filed the PCT, I had to go, it took me an extra 3-4 hours because I hadn't seen the new forms. So I had to go through and download the new forms, compare them against the old forms, and try to figure out what had changed. What I did basically is just checked, you know, they had gotten rid of the box that said, you know, this is the inventor or this is the applicant only for the United States, because the law now allows companies to come in as an applicant. Before, the US was an anomaly. So I checked the right box, but then I made a mistake. When I went to the second part where I'm listing the inventor, what I should have done is checked inventor only. But what I checked instead was applicant and inventor. So, you know, all my efforts to sort of give the company more power, which, you know, the new rules provide, for example, under the new rules, if you file everything properly with the right deck and the right ADS and you have the assignment in place, if the inventor goes hostile, you fill in a form. You know, there's just a little form you fill out as opposed to spending $30,000 trying to prove, you know, that the inventor is hostile. I don't think you can explain to a startup company that you have to spend $30,000 because you made a mistake in the patent law. So the good news is that somebody here is actually at the PCT help desk, and he mentioned to me that it's actually a fairly easy correction all the way up to month 30 to go in and file a substitute page that lists the inventor just as the sole inventor. Some of the procedures that, you know, the way I looked at this was, since I had not that much time to prepare, is I went to the USPTO frequently asked questions. I figured, well, this should be a good source of at least what what the community has issues with. And basically, they had issues with everything. The frequently asked questions included best mode, derivation, user fees, which I'll be covering in more detail, first inventor to file, inter-parties reexamination, inter-parties review, post-grant review, prioritized examination, track 1, which is what we call the pay-to-play track, inventor's oath and declarations, tax strategies, business methods, pre-issuance submission, citations of patent owner statements, supplemental examination. The only thing that wasn't in there was international filing considerations and adapting strategies for the AIA. So, you know, I'll quickly go through those other slides, but basically, you know, I'll go ahead and get to best mode. Basically, it's no longer a basis in patent for validity and infringement proceedings, where the claim can be canceled or held invalid or unenforceable. It does not apply to patent practice, you know, basically the patent examination practice. Now, my understanding is that I may have this confused, but maybe somebody else can clarify, that best mode still can be an issue under other statutes. And I'm going to put that one out there with a grain of salt because I'm not 100% sure on that. Derivation is going to be covered very heavily by Rick, who's going to be coming up next. And basically, of course, as the slide shows, it's basically when somebody, you know, takes something that is yours and tries to claim it. And basically, you know, you have to submit substantial evidence. It has to be filed within 1 year. And it has to be the same or substantially the same as the previous application. Again, I'm going through these very quickly because they've been covered and they will be hit harder later. User fees was another issue that came up that I was supposed to cover in more detail. And I have my own question with respect to user fees. There was a 15% increase that was instituted back in 2011, but apparently the micro-entity discounts were not implemented. Now, I haven't looked at the history enough to understand why they're able to increase the fees by 15%, but not decrease the microentity fees by 75%, but that's, maybe that's a subject of another topic. Prioritized examination is $4,800 to $2,400 for small entity. My understanding is those fees will go down. There's an electronic filing incentive already in place where you pay an extra $400 or $200 depending on small or large entity if you don't file electronically. As I said before, my best practice was always to file electronically and always use the PTO forms. Again, the microentity fees are going to provide a 75% discount to microentities. However, this is supposedly set for, it's supposed to be adjusted based on the fee setting authority provided by Section 10 of the Act. Now, I don't understand why the 15% wasn't there also, but apparently to lower fees, it takes an act, and otherwise, well, anyways, I don't want to go there too much, but I will hit user fees in a little bit more detail later. The main thing that I want to hit about user fees is basically it's pay to play, and it's big bucks. And the reason why I had this sort of depressing scenario at the very beginning is I don't know how small inventors and startups are going to be able to pay to play. For example, I've done a lot of re-examinations, and the fee used to be, I think, around, I forget, $4,200 or so, and I think it's going up to like 16,000 or something like that. I don't know how many startups and small inventors are going to be able to afford that. If you talk about first inventor to file, again, I think the operative word is absolute novelty. Everything I've heard about the safe harbor provision under the one-year grace period seems to indicate that unless you have the identical disclosure, that you're later on relying on, that it doesn't work. A little further. Okay, I think that basically the plan of attack for startups and small inventors is maybe to use the IBM model. IBM gets the most patents every year, and it's part of their business goal. And they have what I understand is a fairly simple process where they have an IP mechanism, IP review mechanism, where ideas come in one end, and a yes/no decision comes out the other end, patent or publish. And when they publish highly technical briefs. I mean, if you've looked at any of IBM's tech briefs, I used to think, IBM is such a great company, they're putting out all this free knowledge, until I became a patent attorney and realized they were creating prior art. They weren't donating anything. And my understanding is if you what they'll do is they'll file a tech brief, very, very detailed, enabling is the operative word, and if later on they get sued for infringement on that same thing that maybe later on they decided to practice, they go to the person, they say, have you seen tech brief number 439? Thank you, go away. Now, this is the strategy that I've used with small inventors and startup companies. I said, look, you got to have a mechanism that says publish or patent. I think now it's even more important, and I think now trade secrets, which I've always talked about with small inventors and startup companies, is even more important. Some other points that I want to make about first to file. Of course, best practices, file electronically, use the USPTO forms, get an assignment as soon as possible. I've heard a lot of talks about generating your own forms that include both the deck and the assignment, so the inventor only has to sign one time. Frankly, the way I'm going to do it is the way I've been doing it already. I file the standard form deck with the standard ADS. As soon as I get a serial number, I send the inventor assignment, and that's usually, you get it the same day. I send the assignment that same day, and I jump on them to get it signed ASAP. And I get on them and get on them and get on them. That's going to become way more important if you want to take advantage of some of the oath and declaration provisions that are in the new law. The other thing that I've heard mentioned is layered provisionals. I've been doing layered provisionals from day one. And the way I explain it to inventors is, think of an onion. You have the heart, and you have the layers of the onion. Well, the heart is the first provisional that you file. It has to be enabling, but for many arts, it's easy. Well, If you have a good patent attorney, you can ensure that it's enabling or at least mitigate any arguments against that. So we file a first provisional that covers what I call the heart of the onion. And then as soon as they have a milestone, and this was the old, basically the old advice, I would say, as soon as you have a substantial milestone, you solve a substantial problem, let's get another provisional on file. And we file as many as we can within that 1 year period. And even up to the PCT filing, we'll update the disclosure. So now every filing has its own filing date and its own prior art date, et cetera. But now I was able to protect a moving target through the whole stage of development. I think that's a very good practice. Of course, it's more expensive because you're filing lots of provisionals. But of course, the way I work with inventors is I teach them how to write applications, which means every application gets cheaper and cheaper and cheaper. Right now, I have clients that are filing applications for my docketing fee. I charge them $500 to docket the case, and they get charged for the docketing fee and some small flat fees because I've trained them how to do it right. You know, I spend maybe an hour at the most with them. That's my model with every single small inventor and startup company to get the process down to as cheap as possible. Somebody talked about, this is basically what I call, teaching somebody to fish instead of selling them the fish. I've always considered trade secrets, and basically the analogy I use, which I think was talked about a little bit earlier, is, if something is super simple to figure out, but has a lot of business value, you should consider a patent. If something has a lot of business value and is very difficult to figure out, chemical formulas, back-end processes behind banks, back-end processes behind software servers, et cetera, you might consider trade secret for that. But what I do is I like to use a combination of trade secret and patents. Basically, I've heard all this talk about non-publication, that you don't want to publish a trade secret. Well, I don't want to patent a trade secret. I want to keep a trade secret, and I want to keep a patent. So for example, when I have clients that are working in cryptography, for example, we'll patent the system at a high level, and it'll be enabling. It'll be enabling with respect to the system. But the actual algorithm, for example, that he's using for some specific purpose, which is, by the way, very, very difficult to figure out, especially if you include firewalls and encryption and lots of mechanisms to keep somebody from reverse engineering, we keep that a trade secret. Somebody mentioned a recent case. I just happened to read a case today. I think it involves the band Motley Crue. Apparently, there's a guy that had showed him this, I might have the wrong band, by the way, but anyways, the drummer was on this track that allowed him to rotate around the stage, like vertically. He was, I guess, strapped into the seat, and he could play drums upside down on this track. And some guy is accusing them of stealing a trade secret because he told them a long time ago about this, and now they're using it, and he wants money. Now, the big issue there is that it was publicly known. There was other people doing the same thing. And I would argue it's easily reverse engineered. I could design that right now, and you could probably design it 100 different ways. So I would be very, very surprised if that particular case actually, if that plaintiff actually prevailed. Inter-parties re-examination, it's been covered already. All I can say is big bucks. This is a pay-to-play. Now, when I say big bucks, I'm talking from a small inventor startup perspective. From an IBM, Nokia, Google perspective, it's chump change. And I won't go into a lot of details, but it elevates the standard. You have to provide a reasonable likelihood that you'll prevail, and there has to be, with respect to at least one claim, challenged. The standard for ex parte reexamination remains unchanged, except for fees. The fees, I think, are super, super high now. I think before they were semi-affordable, and now I think they're out of the range of a startup or a small inventor. Inter-parties review is another pay-to-play provision. I would really like to see how many small inventors and startup companies use this provision unless they already have a lot of money. Post-grant review, another what I consider pay-to-play for startups and small inventors. Again, I won't cover this in excruciating detail since it's already been hit. Prioritized examination, again, another pay-to-play provision. You know, some of the points with respect to prioritized examination, you do get a final disposition within 12 months. I know several colleagues that have been using this examination technique to get patents in 6 months. Now, of course, that raises the issue that was raised earlier about these sort of, what was the right term, bad patents, you know, patents that have gotten examined quickly, but somebody else had actually filed first. You know, it does raise that issue. But it is a provision that might be considered, especially in high-profile technologies like green technologies. You know, the people that I know that have been using it in those sort of things where there's big money and big stakes. The one advantage of this particular provision, there's no search required. You know, unlike accelerated exam, you don't need supporting documents. Apparently, it's limited to 10,000 applications, but it's my understanding the PTO may up that limit going forward. You have to electronic file. As I said before, I think it's a best practice. If you're not electronic filing, you should be. You need a signed deck with the filing. Excess claims at the time of file. You can't have excess claims. You can't have multiple dependent claims. You can have 4 independent claims and 30 claims total. An interesting note, and this is a practice tip with respect to that, you know, another thing that I always do is I always check that box called miscellaneous fees at the EFS web, which basically says, oh, by the way, if I screwed up in my fee calculation, you can charge my deposit account. Well, with these new changes in the law, that is a best practice. If you're not including that authorization on every single thing you have, and if you don't have a deposit account, I suggest you get one and you start using that. And also the request has to be filed at the time of the app filing. Inventor's oath and declaration I covered in a little bit of detail earlier, but again, you know, what I consider the key benefit, and this is one that I'm for, you know, I mean, I told you the reasons. You know, I represented a small startup where we spent $30,000 trying to get rid of a hostile inventor. We eventually did. It took, I think, 8 filings with the PTO before we convinced them that he was hostile. But, you know, it cost the client a lot of money. I think you should take advantage of that provision. You know, I think this is a provision that I think helps startups, and it also helps larger companies. The one person it may not help are the actual inventors working at large companies. And all I can say about that is that read your employment contract, and if you're not happy with the place you're working, go somewhere else. You know, that's my only advice for that segment. Basically, the issue is when to use the old or the new forms. That's the basic issue. And the golden date is September 16th, which has already passed. But it's sort of passed and it hasn't passed because the PTO has the new forms and the old forms. If you file a brand new case right now, you have to use the new forms because it's after September 16th. However, I had the situation where I had filed the US case a year ago, but now I was filing the PCT, and I wanted to take benefit of the oath and deck rules. So what I did is I filed an assignment because the inventor before that hadn't filed an assignment, and I knew it was important to do so. And then I used the new PCT forms, and I was able to list the applicant, but then, like I said, I made the mistake of also listing the inventor as applicant inventor, which I can correct very easily, and which I will do probably later today. So basically, the international filing date is what controls with respect to when you use the new forms and when you use the old forms. Rick is going to cover some other scenarios that can come up with respect to not filing assignments and why it's so important now more than ever to make sure when you file a provisional, when you file anything, get the assignment filed and recorded as quickly as you possibly can, unless you're representing the inventor. In that case, do the opposite. As I said, it simplifies the hostile inventor situations. And the other point that will be hit by some of the other speakers is that the duty to assign in employment contracts is super important now. If you're representing companies that don't have employment agreements, that's already bad. But even if they have employment agreements, you better make sure there's a duty to assign. And also, joint venture has always been a nightmare. You know, one of the, you know, I typically write short white papers whenever I see reoccurring problems. Missing the boat on IP protection, that was the old, you know, when somebody discloses and then they lose all their world rights. Well, now they're probably losing everything, you know, including the US. I also talked about, you know, letting your patent sync with the inventorship. You know, the importance of keeping lab notebooks to keep track of who invented what, so that when you come down the road 5 years later and you're canceling claims, you know how to adjust the inventorship properly. Keeping lab notebooks, which now, you know, like somebody said earlier, oh, it's not that important anymore under the new laws. It's very important because you still have derivation and you still have issues like who is the actual inventor. So like I said, duty to assign is still very important in employment contracts. And by the way, the PTO still wants to know who the inventors are. You know, they still require an oath and deck. And the way you do it now is you do the, you know, you do the, their standard oath and deck, which basically every inventor signs. You know, before you could have one deck that had multiple signatures and had all the other different magic words. Now you have a very short form. Each one gets sent to each inventor, and each one of them signs his own deck. And you know, it's very important now to make sure that you use the forms and that you make sure that things get assigned. Tax strategies, you know, I was reading the comments from the PTO, and it said, applicants will, somebody had a question about tax strategies, and their answer was, applicants will no longer be able to rely solely on novelty or non-obviousness of a tax strategy embodied in their claims in order to distinguish the claims from the prior art. And the question I have is, how else can you distinguish the claims from the prior art? My understanding is tax strategy related patents are dead. You might correct me if I'm wrong, but I'm not 100% certain on that. One thing that I do know is that business methods and tax strategy related patents, the value of those patents have diminished significantly. So you know, luckily I sold one of my e-commerce patent portfolios about a year ago, you know, and thank God we did. As far as the transitional programs for business method patents, I have my own question, and basically it's going to sunset 8 years from the effective date of the provision, which is September 16, 2020. And the question I have is are they just going to kill business method patents altogether by then, or do they hope that they will all be gone by then? Maybe somebody can fill me in on that one. A covered business method review is for all patents issuing from applications directed to a business method or corresponding apparatus performing data processing or other operations, practice, administration, or management of financial product or service, except the term does not include technological inventions. I think we're very quickly heading to the European standard of a technical effect. That's how I'm reading this. And by the way, I've been advising my business method and anybody doing anything related to these, what I call low-tech areas, technology, technology, technology. You know, I had a client that came to me and said, you know, we have doctors that go to people's houses and they look at their faces and they're able to determine disease states. I was thinking Bilski, KSR, all the other possible ways to knock something like that down. And I said, have you considered facial recognition algorithms and doing stuff over the internet with cameras and computers? And I said, if you haven't, you should, and you should put that in your applications. It's even more important now. I don't think anybody is going to use the word business or tax in any patent application going forward. I won't. And again, these technologies, I think, are of low value now. Pre-issuance submission has already been covered, and I won't go into that one into a lot of detail. Basically, you know, an interesting point that I saw as a practice tip with respect to pre-issuance submission is that it has to be made in the application before the notice of allowance is one of the parameters. The other part, the way they answer it is a little trickier because they go, it says the earlier of A, the notice of allowance, or B, the later of. So there's like this, you know, the earlier of this plus the later of that. But anyways, it's the notice of allowance, or also the other things they mention in there is the date of the first rejection. Let's see, the later of 6 months after the date after which the application published, or the date of the first rejection. Now, the practice tip that I heard related to this was to use prioritized examination to get a patent in 6 months, so that hopefully you will not be subject to these pre-submission, pre-issuance submissions. I haven't checked the validity, the validity of that strategy, and I know that somebody mentioned some issues related to prioritized exam and these sort of false patents. And how am I doing time-wise? I know I'm talking way fast. As far as the citations and patent owner statements, you know, that's been covered. The big question that you know, and I hate to be asking questions when I'm presenting, but the question that came to my mind is estoppel. I mean, I look at this and it looks like it's got estoppel written all over it. I might be incorrect, but you know, it's talking about submitting documents in court that are related to the scope of the claims by a patent owner or a third party. I suspect if it's a third party, it's probably going to be, these claims should be this narrow. And I suspect if it's by the patent owner, it's going to be, these claims cover, you know, everything since sliced bread. Supplemental examination, again, another pay-to-pay provision. And again, you know, I guess maybe startups and small inventors will use this once they have funding. I don't really see it being used with some of my clients in the near future. And again, supplemental examination is any information believed to be relevant, and it's not limited to patents and printed publications. It can include any ground of patentability. Patent eligible subject matter, anticipation, obviousness, written description, enablement, best mode, and indefiniteness. Now, the interesting thing that it mentions best mode, and I don't know if that was a mistake in the PTO answer, but my understanding is that, well, I guess best mode, they said best mode is still okay for prosecution, so maybe that's why they put that in there. But anyways, that's another question. And of course, my slides aren't matching up with what I'm talking about, but oath or declaration in more detail. I think I've given you at least the salient points of how I used oath and declaration in a very real-world scenario, which happened to me yesterday. You know, I think the key points are the substitute statement. You know, when an investor is hostile, if you jump through the right loops, if the inventor is deceased, incapacitated, can't be found, refuses to sign, you fill out a form, and you save your client $30,000. You know, I do my forms flat fee. It's probably like, I would probably charge maybe, I don't know, $220 for that. The assignments now can include the magic words. I don't think I'm going to start using those. I think I'm going to still use as my best practice, you know, standard deck form from the PTO, standard ADS, web filed assignment, and then at the PCT level, I'll punch in the right boxes next time. And of course, when you file the deck, you have to use the application data sheet. By the way, if you don't put the priority in the application data sheet, you won't have priority. So using the right forms and using the application data sheet is super, super important now. And if you want to save fees, electronic filing is also very important. If we look at some of the user fees in a little bit more detail, again, I have a question about the microentity, why that's being delayed when the 15% increase was instituted immediately back in 2011. Apparently, PCT fees and certain other fees were not increased by the 15%. And again, practice tip, I like to repeat them often, just like file often, file early. Include authorizations to deposit accounts, include authorizations to deposit accounts, include authorizations to deposit accounts. There's the PTO published a notice of proposed rulemaking regarding its fees using Section 10 of the Fee Setting Authority. They have materials, if you go to the actual presentation, I have the full, you know, this is only a very small portion of all the questions that were asked. But if you go to the presentation, you'll see every single question people asked about these particular topics. But apparently, the public comment period ends November 5th. So if you know, and really, I should be the one that should be, you know, I mean, I have a very personal interest with respect to this because of the fact that I represent small entities and startups. And I'm very, very anxious to get this micro entity 75% discount. Apparently, the office expects most of the new fees could be effective during spring 2013. Again, with respect to user fees, supplemental examination is around $7K for the request, with a supplemental exam costing $20K. Now, tell me how many small inventors and startups can afford $27,000 when they can't even afford $3,000 for a patent. Post-grant review, you know, less than 20 claims, just a mere $35,000. 61 to 70 claims, $125,000. Anything in between or after that in chunks of 10 claims for $35K. What a bargain. Again, pay to play. You know, small inventors and startups, I don't think are going to be playing. Inter-parties review, similar depressing news for small inventors and startups. Less than 20 claims, $27K. 61 to 70 claims, only $95K. And then groups of 10 claims are around $27K. After this, there's a couple of slides that I'm just not going to cover because they're, you know, basically it shows the percentage increase in the various fees. I think I've covered the ones that really got my attention, which are the pay-to-play fees. What is important from this slide, of course, is the micro-entity column. Most of the columns show an increase. That's the one column that shows substantial decreases. That's good news for startups, but I guarantee you that small decrease in the claims fees is no way going to cover the $30,000 to $40,000 to $50,000 they're going to have to spend on the other procedures. Here's another chart with more fees. Again, I'm not going to cover it. By the way, all the fees are listed in the package. So there's a package that includes you know, the complete fee sets and tables. As I said, also the package includes all of the frequently asked questions as of the previous day when I downloaded them and did this presentation. As I said before, the comment period on proposed fees is coming up very quickly, November 5th. And if you represent small inventors and startup companies, please, please tell them that we're already dying. You know, if you want to kill us off completely, just, you know, just wipe out patents for small inventors and micro entities. Let's see here. I'm going to hit prioritized exam in a little bit more detail. And you know, I hate to bore with details, but basically, you know, I didn't know what much else to say about prioritized exam except, you know, big bucks. But required for prioritized exam is the basic filing fee, the search fee, the exam fee, the publication fee, the track 1 processing fee, the track 1 examination fee, all the size fees. You know, if the spec is over 100 sheets, if there's extra independent claims, if there's excess claims. If any fee is unpaid, the request is dismissed. Hence the best practice tip of, you know, have an authorization and a deposit account on everything you send to the patent office, which many practitioners are already doing. This grants special status until the applicant files a petition of extension of time, an amendment, has more than 4 independent claims and more than 30 claims total, or multiple dependent claims. If he files an RCE, if he files a notice of appeal, if there's a suspension for an action, if he files a suspension for an action, if a notice of allowance is mailed, if a final office action is mailed, if the application is abandoned, or if the examination is complete under 37 CFR 41.102. So again, you know, if you do pursue prioritized examination, in addition to paying big bucks, you better have a really, really, really good docketing system that's been updated to include all these possible pitfalls. You know, the PTO is claiming that they've been getting notice of allowances by 4 months, supposedly. I haven't done any of these because I can't afford it, or I should say my clients can't afford it. And let's see, the earlier ones of the 10,000 that are being used are being done, they claim, in about 4 months. Of course, their goal is 1 year. What I've heard from other practitioners is they've been getting patents as early as 6 months. After notice of after non-final office action, the applicant must take charge. There's no publication, no third-party pre-issue submission. Post-grant review may not be available to challenge a patent. And I guess these are the benefits of trying to do prioritized examination, is that if you do this, you might be able to prevent this post-grant review. Again, I had mentioned that there may be some pitfalls in doing that with respect to these hidden patents, but you know, I would argue that a patent is better than no patent, so maybe a hidden patent is better than no patent. International filing considerations. This was taken from you know, a paper that I quickly read. It's from Gene Quinn. Important new changes to the U.S. patent law for PCT applicants. As I mentioned before, I've lived this particular scenario quite recently. But some other situations that, you know, besides the requirements, you know, the fact that now you can have a company act as an inventor, which by the way, I think harmonizes with Europe. I mean, you know, we were the anomaly. In Europe, the applicant could always be the company. Now the U.S. is more like that, and it's going to save a lot of money with respect to these hostile inventor actions. There is a required oath and declaration, and of course, it can be submitted as part of the PCT. However, it's my understanding that if you use the PCT declaration, the current language, at least at the time that I looked at this, is not applicable. So when I did my PCT filing, I didn't use their declaration forms because, according to this, it seemed like it may not comply with the requirements for the AIA. The other thing that came up as a practice tip with respect to this is a lot of clients were doing these dual filings where they would file in the UK and they would file provisional in the US either immediately or, you know, at the same time or very close to that foreign filing date for 102E reasons. It's my understanding now that prior art is available anywhere in the world that it doesn't make sense for companies to multiple file like that. You know, they may just want to file in their own country and not double file in the United States. Please correct me if I'm wrong. As I said, I may know a little bit more than you. Let's see, with respect to international considerations, you don't have to identify the inventors anymore. According to Rick, he said that the PCT safe software might be okay now. The PCT forms have been updated, and I can verify that firsthand because I did a filing recently. Real quickly, practice tips, and you've heard them before, and I'm going to say them again. File as soon as you have an enabling disclosure. This is an important one. Don't do any incest. Keep your pre-AIA filings isolated in their own patent families to limit prior art. So it's going to be important to keep families separate. Absolute novelty. You know, I would discourage filing for the same reason I've been discouraging it before. I mean, I would discourage disclosures for the same reason I was discouraging them before. Pay closer attention to published applications with the new option of submitting prior art, assuming you got the big bucks. Pay extra to get urgent patent applications examined, assuming you have the big bucks. Use supplemental examination to have additional references considered. Once again, pay to play. And keep a patent pending at all times. That was you know, I added this from the notes from one of the other speakers. I've always told startup companies, you always want to keep a patent pending or a patent application pending because you never know how the law is going to change. It turned out to be very, very good advice, and I think it's even better advice now. That's it. I apologize for going so quickly, but am I?
I think if there are any questions, you're going to be available afterwards. We're going to have a
Yeah.
Q&A at the end. Why don't we hold questions and try to keep back on track? Thanks, Carlos.